in summary, some of the conclusions that I've reached, again, I'm going to take a common sense approach to it. If something looks too good to be true, it's just raining money on you. There's probably a problem there, so take a step back, evaluate it, examine it thoroughly. And if it is problematic, you just don't go down that path. You don't go through with a deal. You don't do what Air Maryland did. You don't do what AFG did. And you don't do what American Air Network did. You do not get something for nothing. No, there is no such thing as a no overhead airline. Airline means that it's a business that entails financial risk. And in order to make something successful, and I'm using the term successful with respect to a safe operation that complies with all regulatory requirements, there's great ordeal. It's going to take a lot of time, effort, and financial investment to make it go. You just don't jump off the blocks and get something for nothing. Also, use only approved persons to exercise operational control on the carrier's behalf. So from the flight standards perspective, if it's not qualified management personnel, and if these are not persons designated in the general operations manual as persons to whom operational control may be delegated, then you have to be all over that carrier and tell them they can't do it. And if you are an air carrier, you have to take the first step. Only use qualified management personnel who are approved by FAA and folks who are listed in the General Operations Manual. Have adequate controls in place to ensure that officials in a position of authority over Part 135 flights are conducting those flights in accordance with safety regulations. Those controls include systems to identify problems. And management of your operations should never be lackadaisical. I mean, this is a full-time job. Hands-on management is important. You cannot exist without it. And hands-off management is not a legitimate excuse for failing to exercise operational control. Kent will tell you, or might have told you, that we've looked at some records of management officials. There was one guy who was listed as an official or agent for service. All types of required management official positions and agent for service, I think 170 times. Now, you can't do your job that way. And hopefully, all of you, at some point in time, will have software systems in place where you could punch in a management official for a given operator and see if his name pops up anyplace else. Because you shouldn't be able to be a management official in more than one, for more than one certificate holder. And obviously, if you're in over 100, you're either the best time management guy in the world or you're the best BS artist that I've ever seen. It's one or the other because it's an impossibility. Okay. These are the most recent cases that we've dealt with. There are other cases that we are working on, by the way, and if this were to happen a month or two from now, if we made the same presentation, there might be some additional cases. But I think the other thing that's important now is what we're going to do in the future. I have prepared what I'll characterize as draft compliance and enforcement guidance. I've been with FAA a long time, so I know that even if I had drafted this and watermarked it on my computer draft and disseminated it to a few people, all the world would have it, within and outside of FAA, which I really don't care about, but the thing I do care about is the fact that all would treat it as if it were set in stone today, and it might be tweaked. And so rather than have an inaccurate version kicking around, I figured I'd just speak to it as opposed to disseminating it. It's the intent of Jim Baylog to have the principal operations inspectors issue new op specs to 135 operators, specifically A008 operational control issues, by August 31st, 2006. Now, sometime thereafter, he hasn't selected the exact period of time between the issuance of the new op specs and the time the principal inspector will meet with each certificate holder. But at that point in time, the POI will meet with the carrier to evaluate compliance with the requirements relating to operational control. Now, this new op spec, which Kent will get into in much detail, it's really nothing new. Between 95 and 98% of it is nothing more than the existing state of the law. That means the statute, the Federal Aviation Regulations, and case law. It's not something that you all and the industry is unfamiliar with. And by the way, it's not something that is solely the creation of a couple of policy wonks in Washington, D.C. As I said earlier, policy wonk, as I said earlier, we started working with industry in December. And as Kent said, there's been 16 or 17 revisions, not major things, but they've been tweaks. The initial construction and all the tweaks, there's been participation by representatives of NBAA and NATA. We've had telecons with them, as a matter of fact, regarding this. And at each of these presentations, NBAA and NATA give their website where the audience can, email suggestions that are forwarded to us. So it's not a creation solely of flight standards and attorneys' personnel in Washington, D.C. There's been broad-based participation in it. And rather than the op spec we have now, it's going to set forth in black and white on 4.5, as Ken says, the longest op spec provision in the world, but it's still only 4.5 pages, all of these requirements. And these requirements will supersede anything else. I mean, if a lease agreement, while it should be consistent with this, if it's not, it's still subservient to the op spec that's going to be issued. That will be the governing document. So, when the POI meets with the carrier to evaluate requirements, some of this evaluation will include the following. Has the carrier entered into any leases, contracts, or other agreements under which it has surrendered operational control of Part 135 flights to uncertificated persons, certificated entities whose certificates have been suspended or who are not authorized to conduct that type of operation? And has that been done either now or in the future? Has the necessary management systems and oversight systems been set in place to ensure that air carrier operations meet and will continue to meet the requirements of Parts 119 and 135? Has the authority, does the carrier have in place the authority and systems to initiate, terminate, delay, or redirect flights in air transportation? Is the carrier using unqualified pilots in air carrier operations? Is the carrier flying unairworthy aircraft, or are unairworthy aircraft on its op specs leading to the possibility that such aircraft could be used in air carrier operations? Those are just some of the issues that the principals will get into. Now, once that meeting has taken place, the POI will draw certain Conclusions. If the POI concludes that the carrier is not in compliance with the requirements of the new A008, but the POI has a reasonable basis to expect that the carrier will come into compliance, the carrier will work, the principal operations inspector will work with the air carrier to develop a plan to attain compliance expeditiously. Now, in that situation, there are certain conditions that have to be met. First and foremost, the carrier must immediately cease any conduct or operations that are not in compliance. That means, in essence, that the carrier must stop its operations, set itself down, work on a plan with the principal, get that plan approved before they can come up. Now, if the carrier does not immediately cease this non-compliant conduct, the principal inspector will open an EIR, and the FAA will proceed with an investigation and appropriate enforcement action, including an up to revocation of a certificate. Because at that point in time, when you know you're not in compliance, any operation can be construed as nothing less than a deliberate violation, because you would have been actually placed on notice of any problems that you may have. Now, this isn't a foreign concept, this ceasing operation. I mean, if you think about it, the reporting and correction program, or if you want to call it a voluntary disclosure program, in that situation, if a carrier determines that a problem exists, they immediately notify the FAA. They immediately cease conduct that gave rise to that violation, and they work on a fix with the FAA, and then if it's acceptable to the FAA and they met all the criteria, in other words, it wasn't a deliberate violation, it didn't involve criminal conduct and a couple of other criteria, then we will either waive the civil penalty or we will reduce the amount of sanction. Now, we're not dealing so much sanction here, but we're dealing with the concept of once that problem is identified, you cease the conduct. You step down, you do not continue that operation. Now, if the POI has evidence of that the carrier is not in compliance but does not have a reasonable basis to expect the carrier to come into compliance, the POI will open an EIR and an investigation will be pursued, and if at the conclusion of that investigation there is sufficient evidence to support enforcement action, we will take it. Now, the last area that I want to get into is a little more difficult. If the POI has evidence of past violations, in other words, they are now the carrier is now in compliance with respect to operational control requirements, but there's past conduct relating to operational control issues that is so egregious, so undermines safety, that the POI believes that it warrants enforcement action. In the past, if something like this would have happened, a POI in Texas might do different than a POI in Maine, than in New York, than in Montana, than in California. So what we're trying to do is level the playing field, get a consistency of approach. Now, a little of my background, in addition to supervising attorneys who enforce the federal aviation regulations and the hazardous material regulations, I'm, for better or for worse, involved in every significant legal enforcement action that this agency is involved in. I've been doing that for over a dozen years. So anytime there's a significant enforcement action, I'm the person who initially looks at it to ensure consistency with national policy and sanction guidance. And I've spoken to many people in many headquarter regional offices and many of their attorneys, and before it goes further, we'll get it right if I see that a problem exists. And I work closely with the folks in in the front office of flight standards and the division managers. And with respect to other elements of FAA, do similarly with drug abatement, the folks in aircraft certification, and in hazardous materials and security. So it's something that I'm very familiar with. So in other words, to keep consistency, and hopefully similar decisions will be made with respect to similar facts. And by the way, no two fact situations are identical, but they may be quite similar. So action should be similar too. So when the POI believes that such enforcement action is warranted, he will consult both with AFS 250, Hooper Harris's branch, and with my division, AGC 300, and collectively will work together, analyze the problem, determine if it is a problem that is so egregious that enforcement action is warranted for this past conduct, and if it is, the type and the amount of enforcement action that should be initiated. Now, is it perfect? No. But at least it will be consistent. There is one glitch that I still think we need to work on, and it might be in the form of guidance, so anyone who has an idea will be welcome to it, is what if one principal inspector sees something that is extremely egregious, and let's assume for this situation that we in AFS 250 and AGC 300 feel likewise, but a principal in another part of the country didn't feel that way. We would never even know about it. So that is one issue that we still need to work on. I would make one suggestion. I would say that if, in fact, a company had been renting or franchising out its certificate and it fixed things up and did things right before we initially discovered it, that's probably one area where there should be no doubt that past conduct was so egregious as to warrant legal enforcement action. The issue then would be, based on all the facts and circumstances, what's appropriate. But I'm not going to make that determination. I'm just leaving that thought with you. So that's one thing that I think everyone should be able to agree on with regard to past egregious conduct. In any event, that's all for my prepared presentation. If anyone has any questions, I'd be happy to address them the best that I can, and elicit the help of my colleagues if I have any trouble answering it myself. You want to hand the gentleman the mic, please?
We used to have a phrase that was called the key managers list, and this was a listing of personnel that had been involved with air carrier management, and they were substantially involved in the dissolution of the certificate for one reason or another. And that was supposed to be our guideline to go back and see if a particular individual had a history of non-compliance.
Right.
There was some legal discussion, so would you carry it from there, and is this still a tool that we can use?
Not yet. What the problem is, we do have a provision in 119 that someone who was materially involved in the conduct that gave rise to the revocation could, in essence, be, shouldn't serve in a management position. The issue is due process. What process should they be afforded so they could address that allegation? And that's what we're working on. The type of process and whether or not we need a rulemaking for that, or whether we can do it under our existing Part 13. For example, if you took a revocation action against a carrier for relinquishing operational control, and there was also an action at the same time a revocation action, let's say, against the principal of that company who also had an airman certificate, whose actions substantially contributed to the revocation of the carrier, and they were pretty much the same issues, that guy would have been afforded due process, and he could have been placed on a list, but that's not necessarily what happens. Often the principal of the entity that's relinquished operational control doesn't have a certificate. So we're working on the process, and that might be a regulatory fix. But it's something that should have been done better.
The question right now would be, what legal tool do we as inspectors have to deny an air carrier the appointment or selection of an individual to, say, be director of operations or chief pilot?
Okay. Well, one, there are certain eligibility qualifications for that position set forth in the regulation. That's I'm not done. I'm not done. That's one thing. Now, early on we spoke about North Coast Aviation. No, this was aero leasing, I'm sorry. And in aero leasing, the person who was not approved to exercise operational control would not have been approved to exercise operational control because of his past violation history. Well, if you do have an established past violation history, that's something that can be considered. So you're going to have to look at the nominees from the standpoint of, one, whether they meet the eligibility requirements, whether they, I think another eligibility requirement is compliance.
Compliance, yes.
And do it on a case-by-case basis, not rubber stamp it. Some people, people are people. I don't care if you're flight standards, your attorney, some look at things more diligently than others. I think we all have to make a great effort to look at each of these instances on a case-by-case basis, apply the facts as we know them, and or have to dig a little to ascertain them to each of these cases and go from there.
I agree. I think as we've been looking through these issues, one thing has become clear, and that was that 5% of the people are causing us almost 90% of the problems. An operator may, in fact, go through some sort of revocation. All the management officials resign their positions so that at the time of the revocation, their names are not associated. They simply show up at another operator, and the argument is, well, but I wasn't part of that. As Alan points out, we need a due process to be able to ban, remove people for life, or for some determined period of time, so that we can stop this franchising of certificates, moving or hopping from certificate to certificate. The problem is, unlike DOT, which has this, Alan and I can't do this at the same time. Anyway,
I'm sorry.
that's all right. That we are working on that, and that's one of those things, as Alan says, that we may need regulatory responsibility for.
It is. I'm sorry.
So it is known. Oh, that's the. It is known. We are aware of it, and in fact, I'm going to discuss about this multiple directors of ops and chief pilot that exist in multiple certificates, and trying to alert inspectors of a possibility that this individual may have had a history, or an aircraft may have had a compliance history in the past, so that then you have some criteria to use in determining whether this individual is truly going to exercise operational control. Has shown. Does this individual have a track record of non-compliance?
And one of the issues we've been debating is, I use the term due process. What process is due? Due process doesn't necessarily mean that that someone's entitled to a hearing before an administrative law judge the rules, civil rules of procedure, and that you have to prove it by a preponderance of the evidence. So that's another thing we're sorting out, what process is due. But another thing that we have done, just like I had related with regard to Medway, we said that Mr. Moore, the principal of Medway, while it may be his money on the line, he's going to be isolated from making operational control decisions, at least from the standpoint of being someone who's delegated that authority or is required management personnel. And if he, it'll be the responsibility of the principal inspectors to see if assuming that they do get a certificate, it'll be the principal's responsibility to make sure he's not doing it on the sly, because that is a problem that you could fall into.
Well, the reason I brought this up is because I had 2 cases that I was involved in that resulted in the revocation of the individual airman certificates for conducting illegal charters on a fairly widespread basis. But in these cases, there was no air carrier certificate associated with it.
Okay.
And in one case, the individual suddenly came up to our knowledge that he had been appointed, I think it was director of operations for a 121. And of course, I get a call, and it's like,
well,
and I said, hey, don't talk to me.
But whoa, back off for 1 second. Don't you need in order to be in that required management position, what type of experience do you need?
There are first-time experience requirements and there's recency of experience requirements. So some of the arguments right now on the folks that are running some of these illegal operations, guess who they put forth when they say, all right, we've seen the error of our ways, we've got a certificate. Guess what management officials they put forth? And of course we've said all of the time that they were involved in illegal operations cannot be considered. And quite honestly, I'm questioning, if these management people were telling you to violate the law, why should we believe that they will not continue to give out that sort of advice? I've tried to talk to principal inspectors about that in trying to certainly influence their decision about, well, this individual is in fact a qualified person.
See,
I don't know.
Your scenario, the regulation now says materially contributed to the revocation of the air carrier certificate. They didn't have one.
Yeah.
We should have a little revision to that requirement, or conducted operations without a certificate and had your pilot certificate revoked or something like that. But it doesn't read that way right now.
Well, the second person we dealt with is now deceased, but
that's one way of dealing with it.
Is still around. So
this isn't the folks out of Pennsylvania, is it?
No.
Oh.
I'll talk to you offline.
All right.
Any other questions?
Thank you, Joseph McInnes, Small Main Fisto. Are you going to have any checkpoints in place in regards to if somebody comes to a FSDO requesting 5 certificates?
Say that. I'm sorry.
If a person comes to the FSDO for a certification pre-cert, requesting 5 certificates, that is possibly getting paid $50,000 from somebody down in southern Florida to manage certificates. If that has happened in our office.
5?
We had a gentleman that was a renegade from down south and came up requesting he wanted to manage 5 certificates. After we started digging into it, it was involved that he was going to get a certificate for a company down south in Florida, and he was going to manage everything, totally supposed to be legal, whatever, that they paid him $50,000 for the certificate. We never gave him the certificate, things happened, he went on his way. Now, if something else like that happens again, is there somebody that we, to advise people that this guy's out to, just buy certificates for people?
It seems to me that each applicant should be an applicant for a single certificate?
Well, we started off with one. You know, he put in four other passes. We started off with one, and the GOM was a generic GOM for Gulf Streams, the whole 9 yards, and rejected that. Now, if that flag right there is there, you know, besides, you know, talking with the regional people and letting them know what the situation is there something that should be addressed to just give a heads up to anybody that this is going on?
Do we have any guidance on
No.
Well, it's one certificate, one person, one certificate. So somebody managing, somebody wanting to manage a certificate,
He wanted broker certificates.
broker
Well, I
certificate.
mean, he wanted 5 certificates.
His concept was he was marketing himself in the industry as a professional certificate obtainer. For a $50,000 fee,
Right.
he would go to whatever FSDO was convenient.
Well, that in and of itself is a red flag.
Yeah.
Well, we had nothing that actually said we have.
Well, who is going to be the certificate holder?
Well, he would be the certificate holder.
Well, he can't hold 5 certificates.
He was creating different corporate entities in order to do this. He'd have one airline, another airline, and there's no limit on the corporate structure.
Now, were the different management personnel?
At that time, he was planning on being the primary management person, but he would have different people in different areas. In other words, Certificate A would originally be issued at the port of FSDO. He would be the director of operations, but then he'd have Pilot B as the chief pilot, and he'd be assigned in Tucson, Arizona at some remote base. And he'd have a director of maintenance probably down in Atlanta, Georgia.
What about a second certificate? Same people?
The certificate would be